Moody versus Netchoice LLC, July 1st, 2024. Justice Kagan delivered the opinion of the court. Not even 30 years ago, this court felt the need to explain to the opinion-reading public that the Internet is an international network of interconnected computers. Things have changed since then. At the time, only 40 million people used the Internet. Today, Facebook and YouTube alone have over 2 billion users each, and the public likely no longer needs this court to define the Internet. These years have brought a dizzying transformation in how people communicate, and with it, a raft of public policy issues. Social media platforms, as well as other websites, have gone from unheard of to inescapable. They structure how we relate to family and friends, as well as to businesses, civic organizations, and government. The novel services they offer make our lives better, and make them worse create unparalleled opportunities and unprecedented dangers. The questions of whether, when, and how to regulate online entities, and in particular the social media giants, are understandably on the front burner of many legislatures and agencies. And those government actors will generally be better positioned than courts to respond to the emerging challenges social media entities pose. But courts still have a necessary role in protecting those entities' rights of speech, as courts have historically protected traditional media's rights. To the extent that social media platforms create expressive products, they receive the First Amendment protection. And although these cases are here in a preliminary posture, the current record suggests that some platforms, in at least some functions, are indeed engaged in expression. In constructing certain feeds, those platforms make choices about what third-party speech to display and how to display it. They include and exclude, organize and prioritize, and in making millions of those decisions each day, produce their own distinctive compilations of expression. And while much about social media is new, the essence of that project is something this court has seen before. Traditional publishers and editors also select and shape other parties' expressions into their own curated speech products. And we have repeatedly held that laws curtailing their editorial choices must meet the First Amendment's requirements. The principle does not change because the curated compilation has gone from the physical to the virtual world. In the latter, as in the former, government efforts to alter an edited compilation of third-party expressions are subject to judicial review for compliance with the First Amendment. Today, we consider whether two state laws regulating social media platforms and other websites facially violate the First Amendment. The laws from Florida and Texas restrict the ability of social media platforms to control whether and how third-party posts are presented to other users, or otherwise put, the laws limit the platform's capacity to engage in content moderation to filter, prioritize, and label the varied messages, videos, and other content their users wish to post. In addition, though far less addressed in this court, the laws require a platform to provide an individualized explanation to a user if it removes or alters her posts. Netchoice, an Internet trade association, challenged both laws on their face as a whole, rather than as to particular application. The cases come to us at an early stage on review of preliminary injunctions. The Court of Appeals for the 11th Circuit upheld such an injunction, finding that the Florida law was not likely to survive First Amendment review. The Court of Appeals for the 5th Circuit reversed a similar injunction, primarily reasoning that the Texas law does not regulate any speech and so does not implicate the First Amendment. Today, we vacate both decisions for reasons separate from the First Amendment merits, because neither Court of Appeals properly considered the facial nature of Netchoice's challenge. The courts mainly addressed what the parties had focused on, and the parties mainly argued these cases as if the laws applied only to the curated feeds offered by the largest and most paradigmatic social media platforms, as if, say, each case presented an ace-applied challenge brought by Facebook, protesting its loss of control over the content of its newsfeed. But argument in this court revealed that the laws might apply to and differently affect other kinds of websites and apps. In a facial challenge, that could well matter, even when the challenge is brought under the First Amendment. As explained below, the question in such a case is whether a law's unconstitutional applications are substantial compared to its constitutional ones. To make that judgment, a court must determine a law's full set of applications, evaluate which are constitutional and which are not, and compare the one to the other. Neither court perform that necessary inquiry. To do that right, of course, a court must understand what kind of government actions the First Amendment prohibits. We therefore set out the relevant constitutional principles and explain how one of the courts of appeals failed to follow them. Contrary to what the Fifth Circuit thought, the current record indicates that the Texas law does regulate speech when applied in the way the parties focused on below when applied, that is, to prevent Facebook or YouTube from using its content moderation standards to remove, alter, organize, prioritize, or disclaim posts in its news feed or homepage. The law then prevents exactly the kind of editorial judgments this court has previously held to receive First Amendment protection. It prevents a platform from compiling the third-party speech it wants in the way it wants, and thus from offering the expressive product that most reflects its own views and priority. Still more, the law again, in that specific application, is unlikely to withstand First Amendment scrutiny. Texas has thus far justified the law as necessary to balance the mix of speech on Facebook's news feed and similar platforms, and the record reflects that Texas officials passed it because they thought those feeds skewed against politically conservative voices. But this court has many times held, in many contexts, that it is no job for the government to decide what counts as the right balance of private expression to unbias what it thinks biased, rather than to leave such judgments to speakers and their audiences. That principle works for social media platforms as it does for others. In sum, there is much work to do below on both these cases, given the facial nature of Netchoice's challenges. But that work must be done consistent with the First Amendment, which does not go on leave when social media are involved. As commonly understood, the term social media platforms typically refers to websites and mobile apps that allow users to upload content messages, pictures, videos, and so on to share with others. Those viewing the content can then react to it, comment on it, or share it themselves. The biggest social media companies, entities like Facebook and YouTube, host a staggering amount of content. Facebook users, for example, share more than 100 billion messages every day, and YouTube sees more than 500 hours of video uploaded every minute. In the face of that deluge, the major platforms cull and organize uploaded posts in a variety of ways. A user does not see everything, even everything from the people she follows, in reversed chronological order. The platforms will have removed some content entirely, ranked or otherwise prioritized what remains, and sometimes added warnings or labels. Of particular relevance here, Facebook and YouTube make some of those decisions in conformity with content moderation policies they call community standards and community guidelines. Those rules list the subjects or messages the platform prohibits or discourages, say pornography, hate speech, or misinformation on select topics. The rules thus lead Facebook and YouTube to remove, disfavor, or label various posts based on their content. In 2021, Florida and Texas enacted statutes regulating internet platforms, including the large social media companies just mentioned. The states' laws differ in the entities they cover and the activities they limit. But both contain content moderation provisions, restricting covered platforms' choices about whether and how to display user-generated content to the public, and both include individualized explanation provisions, requiring platforms to give reasons for particular content moderation choices. Florida's law regulates social media platforms as defined expansively that have annual gross revenue of over $100 million or more than 100 million monthly active users. The statute restricts varied ways of censoring or otherwise disfavoring posts, including deleting, altering, labeling, or deprioritizing them based on their content or source. For example, the law prohibits a platform from taking those actions against a journalistic enterprise based on the content of its publication or broadcast. Similarly, the law prevents deprioritizing posts by or about political candidates, and the law requires platforms to apply their content moderation practices to users in a consistent manner. In addition, the Florida law mandates that a platform provide an explanation to a user anytime it removes or alters any of her posts. The requisite notice must be delivered within 7 days and contain both a thorough rationale for the action and an account of how the platform became aware of the targeted material. The Texas law regulates any social media platform having over 50 million monthly active users that allows its users to communicate with other users for the primary purpose of posting information, comments, messages, or images. With several exceptions, the statute prevents platforms from censoring a user or a user's expression based on viewpoint. That ban on censoring covers any action to block, ban, remove, deplatform, demonetize, deboost, restrict, deny equal access or visibility to, or otherwise discriminate against expression. The statute also requires that concurrently with the removal of user content, the platform shall notify the user and explain the reason the content was removed. The user gets a right of appeal, and the platform must address an appeal within 14 days. Soon after Florida and Texas enacted those statutes, Netchoice LLC and the Computer Communications Industry Association, collectively Netchoice, trade associations whose members include Facebook and YouTube, brought facial First Amendment challenges against the two laws. District courts in both states entered preliminary injunctions, halting the law's enforcement. Each court held that the suit before it is likely to succeed because the statute infringes on the constitutionally protected editorial judgment of Netchoice's members about what material they will display. The 11th Circuit upheld the injunction of Florida's law as to all provisions relevant here. The court held that the state's restrictions on content moderation trigger First Amendment scrutiny under this court's cases protecting editorial discretion. When a social media platform removes or deprioritized a user or post, the court explained, it makes a judgment rooted in the platform's own views about the sorts of content and viewpoints that are valuable and appropriate for dissemination. The court concluded that the content moderation provisions are unlikely to survive intermediate, let alone strict, scrutiny because a state has no legitimate interest in counteracting private censorship by tilting public debate in a preferred direction. Similarly, the 11th Circuit thought the statute's individualized explanation requirements likely to fall. Applying the standard from Zotterer v. Office of Disciplinary Counsel of Supreme Court of Ohio, the court held that the obligation to explain millions of decisions per day is unduly burdensome and likely to chill platforms' protected speech. The Fifth Circuit disagreed across the board, and so reversed the preliminary injunction before it. In that court's view, the platform's content moderation activities are not speech at all, and so do not implicate the First Amendment. But even if those activities were expressive, the court continued, the state could regulate them to advance its interest in protecting a diversity of ideas. The court further held that the statute's individualized explanation provisions would likely survive, again, even assuming that the platforms were engaged in speech. Those requirements, the court maintained, are not unduly burdensome under Zotterer, because the platforms needed only to scale up a complaint and appeal process they already use. We granted certiorari to resolve the split between the 5th and 11th Circuits. Netchoice chose to litigate these cases as facial challenges, and that decision comes at a cost. For a host of good reasons, courts usually handle constitutional claims case by case, not en masse. Claims of facial invalidity often rest on speculation about the law's coverage and its future enforcement. and facial challenges threaten to short-circuit the democratic process by preventing duly enacted laws from being implemented in constitutional ways. This court has therefore made facial challenges hard to win. That is true, even when a facial suit is based on the First Amendment, although then a different standard applies. In other cases, a plaintiff cannot succeed on a facial challenge unless he establishes that no set of circumstances exists under which the law would be valid, or he shows that the law lacks a plainly legitimate sweep. In First Amendment cases, however, this court has lowered that very high bar. To provide breathing room for free expression, we have substituted a less demanding, though still rigorous, standard. The question is whether a substantial number of the law's applications are unconstitutional, judged in relation to the statute's plainly legitimate sweep. So in this singular context, even a law with a plainly legitimate sweep may be struck down in its entirety. But that is so only if the law's unconstitutional applications substantially outweigh its constitutional one. So far in these cases, no one has paid much attention to that issue. In the lower courts, Netchoice and the states alike treated the laws as having certain heartland applications, and mostly confined their battle to that terrain. More specifically, the focus was on how the laws applied to the content moderation practices that giant social media platforms use on their best-known services to filter, alter, or label their users' posts. Or more specifically still, the focus was on how the laws applied to Facebook's newsfeed and YouTube's homepage. Reflecting the parties' arguments, the 11th and 5th Circuits also mostly confined their analysis in that way. On their way to opposing conclusions, they concentrated on the same issue: whether a state law can regulate the content moderation practices used in Facebook's newsfeed or near equivalent. They did not address the full range of activities the laws cover, and measure the constitutional against the unconstitutional applications. In short, they treated these cases more like as-applied claims than like facial ones. The first step in the proper facial analysis is to assess the state law's scope. What activities by what actors do the laws prohibit or otherwise regulate? But both, at least on their face, appear to apply beyond Facebook's newsfeed and its ilk. Members of this court asked some of the relevant questions at oral argument, starting with Facebook and the other giants. To what extent, if at all, do the laws affect their other services, like direct messaging or events management? And beyond those social media entities, what do the laws have to say, if anything, about how an email provider like Gmail filters incoming messages, how an online marketplace like Etsy displays customer reviews, how a payment service like Venmo manages friends' financial exchanges, or how a ride-sharing service like Uber runs? Those are examples only. The online world is variegated and complex, encompassing an ever-growing number of apps, services, functionalities, and methods for communication and connection. Each might, or might not, have to change because of the provisions as to either content moderation or individualized explanation in Florida's or Texas law. Before a court can do anything else with these facial challenges, it must address that set of issues in short, and must determine what the law covers. The next order of business is to decide which of the law's applications violate the First Amendment, and to measure them against the rest. For the content moderation provisions, that means asking, as to every covered platform or function, whether there is an intrusion on protected editorial discretion. And for the individualized explanation provisions, it means asking, again, as to each thing covered, whether the required disclosures unduly burden expression. Even on a preliminary record, it is not hard to see how the answers might differ as between regulation of Facebook's newsfeed, considered in the courts below, and, say, its direct messaging service, not so considered. Curating a feed and transmitting direct messages, one might think, involve different levels of editorial choice, so that the one creates an expressive product and the other does not. If so, regulation of those diverse activities could well fall on different sides of the constitutional line. To decide the facial challenges here, The courts below must explore the law's full range of applications, the constitutionally impermissible and permissible both, and compare the two sets. Maybe the parties treated the content moderation choices reflected in Facebook's newsfeed and YouTube's homepage as the law's heartland applications because they are the principal things regulated and should have just that weight in a facial analysis. Or maybe not. Maybe the parties' focus had all to do with litigation strategy, and there is a sphere of other applications and constitutional ones that would prevent the law's facial invalidation. The problem for this court is that it cannot undertake the needed inquiries. We are a court of review, not of first view. Neither the 11th Circuit nor the 5th Circuit performed the facial analysis in the way just described. And even were we to ignore the value of other courts going first, we could not proceed very far. The parties have not briefed the critical issues here, and the record is underdeveloped. So we vacate the decisions below and remand these cases. That will enable the lower courts to consider the scope of the law's applications and weigh the unconstitutional as against the constitutional ones. But it is necessary to say more about how the First Amendment relates to the law's content moderation provisions to ensure that the facial analysis proceeds on the right path in the courts below. That need is especially stark for the Fifth Circuit. Recall that it held that the content choices the major platforms make for their main feeds are not speech at all, so states may regulate them free of the First Amendment's restraints. And even if those activities were expressive, the court held Texas's interest in better balancing the marketplace of ideas would satisfy First Amendment scrutiny. If we said nothing about those views, the court presumably would repeat them when it next considers Netchoice's challenge. It would thus find that significant applications of the Texas law and so significant inputs into the appropriate facial analysis raise no First Amendment difficulties. But that conclusion would rest on a serious misunderstanding of First Amendment precedent and principle. The Fifth Circuit was wrong in concluding that Texas's restrictions on the platform selection, ordering, and labeling of third-party posts do not interfere with expression. And the court was wrong to treat as valid Texas's interest in changing the content of the platform's feed. Explaining why that is so will prevent the Fifth Circuit from repeating its errors as to Facebook's and YouTube's main feeds, and our analysis of Texas's law may also aid the 11th Circuit, which saw the First Amendment issues much as we do, when next considering Netchoice's facial challenge. But a caveat. Nothing said here addresses any of the law's other applications which may or may not share the First Amendment problems described below. Despite the relative novelty of the technology before us, the main problem in this case and the inquiry it calls for is not new. At bottom, Texas law requires the platforms to carry and promote user speech that they would rather discard or downplay. The platforms object that the law thus forces them to alter the content of their expression, particularly edited compilation of third-party speech. That controversy sounds a familiar note. We have repeatedly faced the question whether ordering a party to provide a forum for someone else's views implicates the First Amendment, and we have repeatedly held that it does so if, though only if, the regulated party is engaged in its own expressive activity which the mandated access would alter or disrupt. So too we have held, when applying that principle, that expressive activity includes presenting a curated compilation of speech originally created by others. A review of the relevant precedents will help resolve the question here. The seminal case is Miami Herald Publishing Company versus Tornillo. There, a Florida law required a newspaper to give a political candidate a right to reply when it published criticism and attacks on his record. The court held the law to violate the First Amendment because it interfered with the newspaper's exercise of editorial control and judgment. Forcing the paper to print what it would not otherwise print, the court explained, intruded into the function of editors. For that function was, first and foremost, to make decisions about the content of the paper and the choice of material to go into it. In protecting that right of editorial control, the court recognized a possible downside. It noted the access advocate's view, similar to the state's view here, that modern media empires had gained ever greater capacity to shape and even manipulate popular opinion, and the court expressed some sympathy with that diagnosis, but the cure proposed, it concluded, collided with the First Amendment's antipathy to state manipulation of the speech market. Florida, the court explained, could not substitute governmental regulation for the crucial process of editorial choice. Next up was Pacific Gas Electric Company versus Public Utility, Commission of California, PUI, which the court thought to follow naturally from Tornillo. A private utility in California regularly puts a newsletter in its billing envelopes expressing its views of energy policy. The state directed it to include material from a consumer advocacy group giving a different perspective. The utility objected, and the court held again that the interest in offering the public a greater variety of views could not justify the regulation. California was compelling the utility, as Florida had compelled a newspaper, to carry speech with which it disagreed, and thus to alter its own message. In Turner Broadcasting System, Inc. versus Feet, Turner I, the court further underscored the constitutional protection given to editorial choice. At issue were federal must-carry rules requiring cable operators to allocate some of their channels to local broadcast stations. The court had no doubt that the First Amendment was implicated because the operators were engaging in expressive activity. They were, the court explained, exercising editorial discretion over which stations or programs to include in their repertoire, and the rules interfered with that discretion by forcing the operators to carry stations they would not otherwise have chosen. In a later decision, the court ruled that the regulation survived First Amendment review because it was necessary to prevent the demise of local broadcasting. But for purposes of today's cases, the takeaway of Turner is this holding: a private party's collection of third-party content into a single speech product, the operator's repertoire of programming, is itself expressive, and intrusion into that activity must be specially justified under the First Amendment. The capstone of those precedents came in Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, INT, when the court considered, of all things, a parade. The question was whether Massachusetts could require the organizers of a St. Patrick's Day parade to admit as a participant a gay and lesbian group seeking to convey a message of pride. The court held unanimously that the First Amendment precluded that compulsion. The selection of contingents to make a parade, it explained, is entitled to First Amendment protection, no less than a newspaper's presentation of an edited compilation of speech. And that meant the state could not tell the parade organizers whom to include. Because every participating unit affects the message, said the court. Ordering the group's admittance would alter the expressive content of the parade. The parade's organizers had decided to exclude a message they did not like from the communication they chose to make, and that was their decision alone. On two other occasions, the court distinguished Tornillo and its progeny for the flip-side reason, because in those cases the compelled access did not affect the complaining party's own expression. First, in Pruneyard Shopping Center versus Robbins, the court rejected a shopping mall's First Amendment challenge to a California law requiring it to allow members of the public to distribute handbills on its property. The mall owner did not claim that he, or the mall, was engaged in any expressive activity. Indeed, as the PG court later noted, he did not even allege that he objected to the content of the pamphlets passed out at the mall. Similarly, in Rumsfeld versus Forum for Academic and Institutional Rights, the court reiterated that a First Amendment claim will not succeed when the entity objecting to hosting third-party speech is not itself engaged in expression. The statute at issue required law schools to allow the military to participate in on-campus recruiting. The court held that the schools had no First Amendment right to exclude the military based on its hiring policies, because the schools are not speaking when they host interviews. Or stated again, with reference to the just described precedents, because a law school's recruiting services lack the expressive quality of a parade, a newsletter, or the editorial page of a newspaper, the required accommodation of a military recruiter did not interfere with any message of the school. That is a slew of individual cases. so consider three general points to wrap up. Not coincidentally, they will figure in the upcoming discussion of the First Amendment problems the statutes at issue here, likely present as to Facebook's news feed and similar products. First, the First Amendment offers protection when an entity engaging in expressive activity, including compiling and curating other speech, is directed to accommodate messages it would prefer to exclude. The editorial function itself is an aspect of speech. Or, said just a bit differently, an entity exercising editorial discretion in the selection and presentation of content is engaged in speech activity. And that is as true when the content comes from third parties as when it does not. Again, think of a newspaper opinion page, or, if you prefer, a parade. Deciding on the third-party speech that will be included in or excluded from a compilation and then organizing and presenting the included items, is an expressive activity of its own, and that activity results in a distinctive expressive product. When the government interferes with such editorial choices, say by ordering the excluded to be included, it alters the content of the compilation. It creates a different opinion page or parade, bearing a different message, and in so doing, in overriding a private party's expressive choices, the government confronts the First Amendment. Second, none of that changes just because a compiler includes most items and excludes just a few. That was the situation in Hurley. The Patrick's Day parade at issue there was eclectic. It included a wide variety of patriotic, commercial, political, moral, artistic, religious, athletic, public service, trade union, and eleemosynary themes, as well as conflicting messages. Or otherwise said, the organizers were rather lenient in admitting participants. No matter. A narrow, succinctly articulable message is not the condition of constitutional protection. It is enough for a compiler to exclude the handful of messages it most disfavors. Suppose, for example, that the newspaper in Tornillo had granted a right of reply to all but one candidate. It would have made no difference. The Florida statute still could not have altered the paper's policy. Indeed, that kind of focused editorial choice packs a peculiarly powerful expressive punch. Third, the government cannot get its way just by asserting an interest in improving, or better balancing, the marketplace of ideas. Of course, it is critically important to have a well-functioning sphere of expression in which citizens have access to information from many sources. That is the whole project of the First Amendment, and the government can take varied measures, like enforcing competition laws, to protect that access. But in case after case, the court has barred the government from forcing a private speaker to present views it wished to spurn in order to rejigger the expressive realm. The regulations in Tornillo, Pigi, and Hurley all were thought to promote greater diversity of expression. They also were thought to counteract advantages some private parties possessed in controlling enviable vehicles for speech. Indeed, the Tornillo court devoted 6 pages of its opinion to recounting a critique of the then-current media environment, in particular, the disproportionate influence of a few speakers similar to one heard today, except about different entities. It made no difference. However imperfect the private marketplace of ideas, here was a worse proposal. The government itself deciding when speech was imbalanced and then coercing speakers to provide more of some views or less of others. Whatever the challenges of applying the Constitution to ever-advancing technology, the basic principles of the First Amendment do not vary. New communications media differ from old ones in a host of ways. No one thinks Facebook's newsfeed much resembles an insert put in a billing envelope. And similarly, today's social media pose dangers not seen earlier. No one ever feared the effects of newspaper opinion pages on adolescents' mental health. But analogies to old media, even if imperfect, can be useful. And better still, as guides to decision, are settled principles about freedom of expression, including the ones just described. Those principles have served the nation well over many years, even as one communications method has given way to another, and they have much to say about the laws at issue here. These cases, to be sure, are at an early stage. The record is incomplete, even as to the major social media platforms' main feeds, much less the other applications that must now be considered. But in reviewing the district court's preliminary injunction, the Fifth Circuit got its likelihood of success finding wrong. Texas is not likely to succeed in enforcing its law against the platform's application of their content moderation policies to the feeds that were the focus of the proceedings below. And that is because of the core teaching elaborated in the above summarized decisions. The government may not, in supposed pursuit of better expressive balance, alter a private speaker's own editorial choices about the mix of speech it wants to convey. Most readers are likely familiar with Facebook's news feed or YouTube's homepage. Assuming so, feel free to skip this paragraph, and maybe a couple more. For the uninitiated, though, each of those feeds presents a user with a continually updating stream of other users' posts. For Facebook's news feed, any user may upload a message, whether verbal or visual, with content running the gamut from vacation pictures from friends to articles from local or national news outlets. And whenever a user signs on, Facebook delivers a personalized collection of those stories. Similarly, for YouTube, its users upload all manner of videos, and any person opening the website or mobile app receives an individualized list of video recommendations. The key to the scheme is prioritization of content, achieved through the use of algorithms. Of the billions of posts or videos, plus advertisements, that could wind up on a user's customized feed or recommendations list, only the tiniest fraction do. The selection and ranking is most often based on a user's expressed interests and past activities, but it may also be based on more general features of the communication or its creator. Facebook's community standards and YouTube's community guidelines detail the messages and videos that the platforms disfavor. The platforms write algorithms to implement those standards, for example, to prefer content deemed particularly trustworthy or to suppress content viewed as deceptive, like videos promoting conspiracy theories. Beyond rankings lie labels. The platforms may attach warnings, disclaimers, or general commentary, for example, informing users that certain content has not been verified by official sources. Likewise, they may use information panels to give users context on content relating to topics and news prone to misinformation, as well as context about who submitted the content. So, for example, YouTube identifies content submitted by state-supported media channels, including those funded by the Russian government. But sometimes the platforms decide providing more information is not enough. Instead, removing a post is the right course. The platform's content moderation policies also say when that is so. Facebook standards, for example, prescribe posts with exceptions for newsworthiness and other public interest value in categories and subcategories, including violence and criminal behavior, such as violence and incitement, coordinating harm and publicizing crime, fraud and deception, safety, such as suicide and self-injury, sexual exploitation, bullying and harassment. YouTube's guidelines similarly target videos falling within categories like hate speech, violent or graphic content, child safety, and misinformation, including about elections and vaccines. The platforms thus unabashedly control the content that will appear to users, exercising authority to remove, label, or demote messages they disfavor. Except that Texas law limits their power to do so. As noted earlier, the law's central provision prohibits the large social media platforms, and maybe other entities, from censoring a user's expression based on its viewpoint. The law defines expression broadly, thus including pretty much anything that might be posted, and it defines censor to mean block, ban, remove, deplatform, demonetize, deboost, restrict, deny equal access or visibility to, or otherwise discriminate against expression. That is a long list of verbs, but it comes down to this. The platforms cannot do any of the things they typically do on their main feeds. To posts they disapprove, cannot demote, label, or remove them whenever the action is based on the post viewpoint. And what does that based on viewpoint requirement entail? Doubly, some of the platform's content moderation practices are based on characteristics of speech other than viewpoint, such as on subject matter. But if Texas law is enforced, the platforms could not, as they in fact do now, disfavor posts because they support Nazi ideology, advocate for terrorism, espouse racism, Islamophobia, or anti-Semitism, glorify rape or other gender-based violence, encourage teenage suicide and self-injury, discourage the use of vaccines, advise phony treatments for diseases, advance false claims of election fraud. The list could continue for a while. The point of it is not that the speech environment created by Texas law is worse than the ones to which the major platforms aspire on their main feeds. The point is just that Texas law profoundly alters the platform's choices about the views they will and will not convey. And we have time and again held that type of regulation to interfere with protected speech. Like the editors, cable operators, and parade organizers, this court has previously considered the major social media platforms are in the business, when curating their feeds, of combining multifarious voices to create a distinctive, expressive offering. The individual messages may originate with third parties, but the larger offering is the platform. It is the product of a wealth of choices about whether and, if so, how to convey posts having a certain content or viewpoint. Those choices rest on a set of beliefs about which messages are appropriate and which are not, or which are more appropriate and which less so. In the aggregate, they give the feed a particular expressive quality. Consider again an opinion page editor, as in Tornillo, who wants to publish a variety of views but thinks some things off limits, or, to change the facts, worth only a couple of column inches. The choice of material, the decisions made as to content, the treatment of public issues, whether fair or unfair, all these constitute the exercise of editorial control and judgment, for a paper and for a platform too. And the Texas law, like Florida's earlier right for reply statute, targets those expressive choices in particular by forcing the major platforms to present and promote content on their feeds that they regard as objectionable, that those platforms happily convey the lion's share of posts submitted to them makes no significant First Amendment difference. To begin with, Facebook and YouTube exclude, not to mention label or demote, lots of content from their newsfeed and homepage. The community standards and community guidelines set out in copious detail the varied kinds of speech the platforms want no truck with, and both platforms appear to put those manuals to work. In a single quarter of 2021, Facebook removed from its newsfeed more than 25 million pieces of hate speech content and almost 9 million pieces of bullying and harassment content. Similarly, YouTube deleted in one quarter more than 6 million videos violating its guidelines, and among those are the removals the Texas law targets. What is more, this court has already rightly declined to focus on the ratio of rejected to accepted content. Recall that in Hurley, the parade organizers welcomed pretty much everyone, excluding only those who expressed a message of gay pride. The court held that the organizers' lenient admissions policy and the resulting failure to express a particularized message would not forfeit their right to reject the few messages they found harmful or offensive. So too here, though the excluded viewpoints differ. That Facebook and YouTube convey a mass of messages does not license Texas to prohibit them from deleting posts with, say, hate speech based on sexual orientation. It is as much an editorial choice to convey all speech except in select categories as to convey only speech within them. Similarly, the major social media platforms do not lose their First Amendment protection just because no one will wrongly attribute to them the views in an individual post. For starters, users may well attribute to the platforms the messages that the posts convey in toto. Those messages communicated by the feeds as a whole derive largely from the platform's editorial decisions about which posts to remove, label, or demote. And because that is so, the platforms may indeed own the overall speech environment. In any event, This court has never hinged a compiler's First Amendment protection on the risk of misattribution. The court did not think in Turner and could not have thought in Tornillo or Pijuet that anyone would view the entity conveying the third-party speech at issue as endorsing its content. Yet, all those entities, the court held, were entitled to First Amendment protection for refusing to carry the speech. To be sure, the court noted in Pruneyard and Fair when denying such protection, that there was little prospect of misattribution. But the key fact in those cases, as noted above, was that the host of the third-party speech was not itself engaged in expression. The current record suggests the opposite as to Facebook's news feed and YouTube's homepage. When the platforms use their standards and guidelines to decide which third-party content those feeds will display, or how the display will be ordered and organized, they are making expressive choices. And because that is true, they receive First Amendment protection. And once that much is decided, the interest Texas relies on cannot sustain its law. In the usual First Amendment case, we must decide whether to apply strict or intermediate scrutiny. But here we need not. Even assuming that the less stringent form of First Amendment review applies, Texas law does not pass. Under that standard, a law must further a substantial governmental interest that is unrelated to the suppression of free expression. Many possible interests relating to social media can meet that test. Nothing said here puts regulation of Netchoice's members off limits as to a whole array of subjects, but the interest Texas has asserted cannot carry the day. It is very much related to the suppression of free expression, and it is not valid, let alone substantial. Texas has never been shy and always been consistent about its interest. The objective is to correct the mix of speech that the major social media platforms present. In this court, Texas described its law as responding to the platform's practice of favoring certain viewpoints. The large social media platforms throw out, or encumber, certain messages. Texas wants them kept in and free from encumbrances because it thinks that would create a better speech balance. The current amalgam, the state explained in earlier briefing, was skewed to one side, and that assessment mirrored the stated views of those who enacted the law, save that the latter had a bit more color. The law's main sponsor explained that the West Coast oligarchs who ran social media companies were silencing conservative viewpoints and ideas. The governor, in signing the legislation, echoed the point. The companies were fomenting a dangerous movement to silence conservatives. But a state may not interfere with private actors' speech to advance its own vision of ideological balance. States and their citizens are of course right to want an expressive realm in which the public has access to a wide range of views. That is, indeed, a fundamental aim of the First Amendment. But the way the First Amendment achieves that goal is by preventing the government from tilting public debate in a preferred direction. It is not by licensing the government to stop private actors from speaking as they wish and preferring some views over others. And that is so even when those actors possess enviable vehicles for expression. In a better world, there would be fewer inequities in speech opportunities, and the government can take many steps to bring that world closer. But it cannot prohibit speech to improve or better balance the speech market. On the spectrum of dangers to free expression, there are few greater than allowing the government to change the speech of private actors in order to achieve its own conception of speech nirvana. That is why we have said in so many contexts that the government may not restrict the speech of some elements of our society in order to enhance the relative voice of others. That unadorned interest is not unrelated to the suppression of free expression, and the government may not pursue it consistent with the First Amendment. The court's decisions about editorial control, as discussed earlier, make that point repeatedly. Again, the question those cases had in common was whether the government could force a private speaker, including a compiler and curator of third-party speech, to convey views it disapproved of. And in most of those cases, the government defended its regulation as yielding greater balance in the marketplace of ideas. But the Cortam Tornillo, in Page, and again in Hurley, held that such an interest could not support the government's effort to alter the speaker's own expression. Our cases establish, the PG Court wrote, that the state cannot advance some points of view by burdening the expression of others. So the newspaper, the public utility, the parade organizers, whether acting fairly or unfairly, could exclude the unwanted message, free from government interference. The case here is no different. The interest Texas asserts is in changing the balance of speech on the major platforms' feeds, so that messages now excluded will be included. To describe that interest, the state borrows language from this court's First Amendment cases, maintaining that it is preventing viewpoint discrimination. But the court uses that language to say what governments cannot do. They cannot prohibit private actors from expressing certain views. When Texas uses that language, it is to say what private actors cannot do. They cannot decide for themselves what views to convey. The innocent-sounding phrase does not redeem the prohibited goal. The reason Texas is regulating the content moderation policies that the major platforms use for their feeds is to change the speech that will be displayed there. Texas does not like the way those platforms are selecting and moderating content and wants them to create a different expressive product communicating different values and priorities. But under the First Amendment, that is a preference Texas may not impose. These are facial challenges, and that matters. To succeed on its First Amendment claim, Netchoice must show that the law at issue, whether from Texas or from Florida, prohibits a substantial amount of protected speech relative to its plainly legitimate sweep. None of the parties below focused on that issue, nor did the Fifth or 11th Circuits. But that choice, unanimous as it has been, cannot now control. Even in the First Amendment context, facial challenges are disfavored, and neither parties nor courts can disregard the requisite inquiry into how a law works in all of its application. So on remand, each court must evaluate the full scope of the law's coverage. It must then decide which of the law's applications are constitutionally permissible and which are not, and finally weigh the one against the other. The need for Netchoice to carry its burden on those issues is the price of its decision to challenge the laws as a whole. But there has been enough litigation already to know that the Fifth Circuit, if it stayed the course, would get at least one significant input into the facial analysis. The parties treated Facebook's news feed and YouTube's homepage as the heartland applications of the Texas law. At least on the current record, the editorial judgments influencing the content of those feeds are, contrary to the Fifth Circuit's view, protected expressive activity, and Texas may not interfere with those judgments simply because it would prefer a different mix of messages. How that matters for the requisite facial analysis is for the Fifth Circuit to decide. But it should conduct that analysis in keeping with two First Amendment precepts. First, presenting a curated and edited compilation of third-party speech is itself protected speech. And second, a state cannot advance some points of view by burdening the expression of others. To give the government that power is to enable it to control the expression of ideas, promoting those it favors and suppressing those it does not. And that is what the First Amendment protects all of us from. We accordingly vacate the judgments of the Courts of Appeals for the Fifth and 11th Circuits and remand the cases for further proceedings consistent with this opinion. It is so ordered.